This conference will now be recorded.
So I'd like to welcome everybody who's joining me this evening. My name is Stephanie Schneider. I'm a board-certified elder law attorney in South Florida, and today is February 22nd, 2021. And tonight's topic is estate planning for parents who have a special needs child or a minor age child or adult children. So we're going to be covering a lot of information this evening. So the planning that we're going to talk about this evening is relevant regardless of your marital status. You could be married, single, widowed, or divorced. The planning is still essential for you as well as your family. So there are different parts to creating a plan, and we're going to go through each one. First, there's what we call an estate plan, which focuses on how we're going to pass on assets at the time of our demise, whether it be our home, bank accounts, investments, or other types of assets. And there's two main tools that we use for this purpose. One is called a last will and testament, and the other is called a revocable trust. Both of those tools allow us to choose who is going to inherit, what we call our beneficiaries, and it allows us to select a trusted person to take on the responsibility when we die to gather the assets and follow the instructions in the legal document. In a will, we call that person a personal representative. In a trust, we refer to that person as a trustee. Both these people have what we call a fiduciary duty. They're held to a high standard of care in managing the assets and making proper distribution to the beneficiaries. Now, there's a second part of the plan that's just as important, and I call this the incapacity plan. It's not that we're planning to become sick or incapacitated sometime in the future. Rather, it's that we have a management plan in place, so if that does happen, everything can run smoothly. Our family doesn't have to panic or worry about how they're going to make financial or medical decisions for us. So both the estate plan and the incapacity plan need to work together. We don't want to just have one without the other. Tonight, we're also going to talk about planning for our children at different ages. And this is very important because thankfully in Florida, we've got a lot of tools that our state laws give us to do this kind of planning and to think ahead. So throughout tonight's webinar, I'm going to offer different tips. And one of the first tips is to avoid using the internet. You know, I tell my 13-year-old, everything that you read on the internet is not true, no matter how convincing it might appear. And that includes legal advice that you see. If you don't know the source, you have to be careful and be an informed consumer. So some of the mistakes people make when they rely on the internet is, for example, they might use a site like LegalZoom to create documents for themselves. And the danger of doing it that way is that you don't get the opportunity to talk with an educated, experienced attorney. You don't get to have the dialogue where you share important facts about you, your spouse, your children. And that really needs to happen so that the documents reflect your needs and how those needs are going to be met now and in the future. It's the same if you go to a store like Office Depot and you ask them, you know, do you have a will kit that I can buy? You're not going to converse with an attorney there who's going to be able to tell you the proper way things should be done. So this is an investment in our future. Just like we buy insurance for our home or our car, to protect us in case there's a fire or a car accident. We want to do the same with our legal plan. So first, I'm going to talk a little bit about a will, how it works, and we're going to lead into trust and, more importantly, special needs trust. So sometimes people think that when they make a last will and testament, it means that their assets are not going to go through the probate process. That's the court system. And it's a mechanism that the ownership of our assets are transferred to become property of our beneficiaries. Well, in reality, having a will doesn't mean that. It means that we get to choose who inherits as well as who we don't want to inherit. It means that we get to choose that trusted person, the fiduciary I mentioned a few minutes ago. And it also allows us to choose how the beneficiary is going to inherit. So if you're speaking with an attorney and you share with that person that you have a loved one with special needs, or perhaps a family member that maybe isn't fiscally responsible or might have some sort of addiction challenge, then there are different kinds of trusts that can be written to protect the beneficiary and try to make their inheritance last as long as possible for them. So you can start to see why having that conversation is so important. And there are many different kinds of trusts for different purposes. Another tip I want to share with everybody tonight is it's a better choice to use percentages rather than using dollar amounts when your will is written. Now, why do you think that's the case? Well, it's simply because nobody has a crystal ball that we can look into and tell you with certainty what the value of your assets is going to be on the day that you pass. And there is an unfortunate result that can happen if you use dollar amounts for certain beneficiaries and then say, I want the rest to go equally to the remaining beneficiaries. And the problem that it creates is if there's not enough assets to satisfy the people that you want to leave specific dollar amounts to, as well as taking care of the other beneficiaries, it means that the other beneficiaries won't inherit anything at all. And it's an unfortunate result that most people don't intend for it to happen. It happens accidentally because they don't know this important tip. So I do recommend working with percentages. If you can remember back to grade school when we were learning fractions in math class, and the teacher would draw a circle, a pie on the blackboard, and then start to carve out slices. That was how we learned fractions. So we use the same thing in estate planning. You get to choose the size of the percentage. Some could be smaller than others. You might want to treat certain beneficiaries differently. As long as the percentages total 100%, it means that every beneficiary that you have designated is going to inherit something. Nobody will be accidentally disinherited. So keep that in the back of your minds as you're thinking about who you want to name and what amounts you would like to leave to each beneficiary. Now, when we have a beneficiary who might have special needs or a disability or perhaps an illness or an accident that is going to affect them long term, we don't want the inheritance to accidentally cause them to lose their entitlement to government benefit programs. So some benefit programs are financially sensitive. For example, one of the programs under the Social Security Administration is called SSI. It stands for Supplemental Security Income. And in order to qualify, a person has to have limited resources of no more than $2,000 and limited income every month. When a person qualifies for SSI in Florida, they are automatically approved for basic Medicaid assistance. And Medicaid is the agency that pays for health care. So that could be the doctor's visit, prescriptive medications, hospitalization, depending on where the person is living. It could pay for home health aides to come into the home environment. So these programs are financially sensitive, and because they're financially sensitive, we want to make sure that an inheritance is put into a special needs trust, because under federal law, that money, those assets, are protected. The government knows they're there, but they won't count them as being available to the individual that is receiving government benefits. And the reason for that is because the beneficiary of the special needs trust will not be the trustee. They will not be in charge. They will not be making decisions. And so for that reason, the agencies know that the person can't just reach into the trust and access the assets. So it's important to think about who you would trust, who is responsible and willing to take on the role as a trustee of the Special Needs Trust. Now, it does not necessarily need to be a person that is living in the same state as the trust beneficiary. And the reason I say this is we live in a world of technology, and so a lot of things can be handled long distance. And if there are other family members near the beneficiary, they can relay information to the trustee to help the trustee make decisions on what to spend the assets on to improve the quality of life and quality of care of the beneficiary. If there are no family members geographically near the beneficiary, then another option is the trustee could hire a care manager. A care manager, by training and background, is either a social worker or could be a nurse. And there are care managers that deal with all different age groups. Some focus on older adults, some focus on children, some focus on young adults. And so they can be the eyes and ears for the trustee and help the beneficiary to navigate through the healthcare system as well as the government benefit systems. So they're also a very important resource for both the trustee as well as the trust beneficiary. Now, if you're thinking about having a special needs trust for somebody, you also want to think about naming at least one successor trustee. I recommend naming more than one, again, because we have no crystal ball that we can look into and tell a client in advance, will their trustee or their first successor trustee be healthy when the time comes? So it's a good idea, since we're taking the time to create this management system, it's a good idea to think of alternate trustees. And as you go through this process, I do recommend before you meet with an attorney that you have an open dialogue with the people you're thinking of naming as trustee. This should not come as a surprise to anybody after your document has been written and signed. You really want to share the information with them, ask them if this is something that they're willing to do, and invite their participation. Now, another decision you'll need to make is whether you want to compensate the trustee for their time that they're going to spend in the future to manage the special needs trust. There is no requirement to compensate. It's purely a personal decision. Some people may decide on compensation and others may decide just to provide for reimbursement of any out-of-pocket expenses that the trustee might incur. We also have to think down the road as to who should inherit any assets that might be left in the special needs trust when the beneficiary passes away. And because this is a type of special needs trust that is not accessible to Medicaid, there is no Medicaid lien that will attach, it allows you to determine who will inherit any remaining monies at the very end. And we call that naming a residuary beneficiary. The word residue simply means what's left at the end. So you might decide to leave it to a charity, you might decide to leave it to other relatives. You have a whole variety of choices. And as I mentioned, there is no payback to Medicaid on this kind of special needs trust because the assets are being inherited. They came from somebody other than the beneficiary. So there is no payback to Medicaid, and we never have payback at death to Social Security of the SSI benefits. Another tip I want to share with everybody tonight is I encourage everybody to get their legal plans in place sooner rather than later. And I know that it's easy to say and it's not so easy to do. You know, we all get caught up in whatever's happening in our lives. It could be if we have young children, the time that it takes to get them up in the morning, get them dressed, fed, off to school, then getting ourselves to a job. Or we might be older and we might be helping to raise grandchildren. So I know that our days get very busy no matter where we live or what stage of life we're in. But sometimes we can lose a window of opportunity to do the planning. And that's why I encourage everybody to do it sooner rather than later. You know, one of the things that I've observed in the last year that we are all living with this virus is that many people were caught off guard. They didn't have their incapacity plan. They had no medical advance directives. Nobody was named to speak for them and make medical decisions when they couldn't talk. Or nobody was named in a durable power of attorney to make financial decisions when they were sick because of the virus. So I'd like everybody who's joining me tonight to learn from some of the mistakes that other people have made and use it to do it differently for you and your family. So now we're going to talk a little bit about the revocable trust and compare it to understand how is it different than having a last will and testament. So I said with the last will and testament, the assets are going through the court system called probate in order to get to the beneficiaries. With a revocable trust, the assets are going to the beneficiaries outside of probate through a more private process. So the trust agreement is not filed with the court. It's not a public record anywhere. It remains private unless, you know, it is shared with the beneficiaries and the trustee. So because of that, your neighbors, your friends are not going to be privy to the decisions you made. And this might be important for certain people. Some of the similarities is that in both documents, we need to name a fiduciary. So with a trust, we would be the original trustee while we're alive and we're healthy and we can handle making financial decisions, but we still need to name that successor trustee, similar to naming a successor personal representative in the will. Another similarity is we might want to consider whether to compensate the successor trustee who's going to handle our financial affairs when we're incapacitated or after we've passed away. Or we might choose just to reimburse that person for out-of-pocket expenses. Similar to a will, we're going to select beneficiaries and we're going to determine the amount of each person's inheritance. So the tip I shared earlier about working with percentages rather than dollar amounts would still apply if you choose to have a revocable trust rather than just a last will and testament. Now there is one big difference between the will and the trust, and that is after the document is prepared and signed, there's another important step that needs to be taken. And we call that step transferring the assets to the trust. So we need a way for the ownership of the assets to move from your name to the name of your trust. And so it may mean going to the bank and having the name, the title on the bank account changed. Or if you have an investment account, it would mean contacting your financial advisor, providing that person with the signed trust agreement, and they will then change the title on the account. When it comes to real estate would be changed by creating what's called a deed. A deed reflects the ownership of the property. And so a new deed would be prepared to transfer the ownership from you into your revocable trust. So this is a really important step, because if this step is not taken, then the trust is considered to be empty. If you imagine having a vase on a table, you first add water to the vase and then you put the flowers in it. So the vase is full. In the same way, we have to fill up the trust. So the document starts to create the trust, but until we put the ownership of the assets into the trust is not full. So sometimes estate planning can feel a little bit like going through a maze. Which direction do I go in? What's the right thing for me, for my family? And so the tip I want to share with you is don't try this yourself. You know, the benefit of coming to an experienced attorney is to be able to look at all the different options and determine which is the best one for you. And in addition to that, to make sure that all aspects of your plan are coordinated. So what do I mean? Well, there's a thing that we call beneficiary designations. So certain assets allow us, when we first purchase them, to designate a beneficiary right on the contract. An example would be when we purchase a life insurance policy. On the application, it asks us who would we like to name as our primary beneficiary and as our secondary beneficiary. We can also do this with annuities and even bank accounts. The problem occurs when people designate a beneficiary on an asset that's different from who they're designating as a beneficiary in their will or in their trust. I'll give you an example. Let's say somebody has 3 children, but there's one particular child that lives close by and helps the parent out. So the parent decides to designate that one child as a beneficiary on either a life insurance policy or a bank account. But their will names all 3 children to inherit the assets equally. Well, what happens when the parent passes away is 2 different results. The first result is that the life insurance company will only distribute the proceeds to the child whose name is listed as the beneficiary. Now, that beneficiary is under no legal obligation to share the proceeds with anybody else. The assets that the will is going to control is going to be distributed to all three children because that's what the will says. So we want to make sure that beneficiary designations coordinate and coincide with what's written in the will or what's written in the revocable trust. We can also unintentionally create a problem when designating a beneficiary if we designate a minor, somebody who is under age 18. And the reason that is problematic is because children by law cannot hold assets. They don't have the maturity, they don't have the life experience. So somebody has to do that for them. So if a minor is designated as a beneficiary of an asset, unfortunately, the company is going to instruct the parents of the minor to become appointed as legal guardians. And until the court paperwork is produced, they're not going to release the assets. So it could be that if you want a minor to inherit assets, that we want to create a trust for that minor and put somebody in charge of handling that trust until the child reaches a certain age that we think might reflect some maturity in being able to handle the inheritance. We can also unintentionally create a problem if we designate a beneficiary on an asset and that beneficiary is receiving financially sensitive government benefits. We talked about that a few minutes ago. So the problem is that that beneficiary is going to receive the money directly, and once they receive it, it's going to be considered countable resources under Medicaid and under the SSI program. So the lesson here is we want to coordinate any beneficiary designations with the plan that we're creating in the will or in the trust. So those are some of the tools that are available to us for the estate plan. Now, it's equally as important to create the incapacity plan. And I like to break down the incapacity plan into two parts. We're going to talk about the financial part first, and then we're going to touch on the medical decision-making part of the plan. So the key tool that we use for financial decision-making when somebody's incapacitated is called the durable power of attorney. Now, it's a very important document, a very serious document, so we want to carefully think through who we are going to give permission to step into our shoes and make financial decisions if we're sick, disabled, or incapacitated. Now, I want to pause here for a minute because there's, as I said, a lot of misinformation on the internet. So when you give somebody a durable power of attorney, you are giving them a significant amount of control, but you're not giving them ownership. They're not becoming an owner of your assets. And the nice thing about that is if the person you name in the power of attorney has any kind of financial hardship, that could be they get divorced, maybe their business doesn't do well and they file for bankruptcy. Because they don't own your assets, it means your assets are protected from their financial situations. So having a durable power of attorney, I think, is a much better approach than adding somebody's name onto an asset as a joint owner, because then they do own half, and that asset could be subject to any kind of divorce proceeding or bankruptcy. So I wanted to clarify that. Now, we used to have in Florida two types of powers of attorney. However, our law changed in October of 2011, and now we only have one type of power of attorney. The kind of power of attorney we have is effective as soon as you sign the document. So even though you might be healthy, you're in full control of making financial decisions, the document is considered effective. So if you're not ready to have the person you've given permission to start to make financial decisions, then you don't want to give them the original and you don't want to give them a copy of the document. Prior to 2011, we could write what were called springing powers of attorney. That said, the document would not be effective until a person's doctor examined them and signed an affidavit to prove that they were now incapacitated. Now, I know we have some people joining us this evening who reside outside of Florida, so understand that each state can make its own laws and rules about when a power of attorney is effective. So you'll want to check with a licensed attorney in the state where you live. Here in Florida, we have what are called superpowers that are spelled out in the document. So superpowers are high levels of financial decision making, and we have to decide, are we going to give permission for those kinds of decisions to be made, or are we going to withhold the ability for those decisions to be made? So some of the examples of superpowers in Florida include the ability to make a gift of your assets, the ability to create or modify a trust document, the ability to disclaim property that somebody else left for you, or the ability to waive certain inheritance rights that if you're married, you're entitled to under Florida law. So it's important to understand the superpowers and to have examples of what they practically mean so that when you make your decisions, you're making informed decisions. You may or may not have another opportunity down the road to change or update your durable power of attorney. So you want to take the time to think through everything carefully. Now, earlier you heard me say that planning is important no matter the marital status of the person. Single and married people need to have an incapacity plan, and there's no difference for people that are married. You might tend to assume that your spouse can make financial or medical decisions for you, but you might be surprised to learn that if your spouse's name is not on an asset that you have, that being married doesn't give them that permission. So durable power of attorney is important for everybody, single and married. Anyone over age 18 is considered a legal adult in the state of Florida. So some of us who do have older children, I have two stepchildren, one is in their early 20s, the other is in their mid 30s. You might tend to think, well, my child really doesn't have much by way of assets. They might have a small bank account, they bought a car. It's still important to have because we're trying to plan for the future. And the future includes assets that they could acquire. It's also important in case our children are in college and something happens and they have to leave school. If they have student loans, we want to have the legal authority to communicate with the loan company. So there are a lot of different reasons why it's important for anyone over age 18 to have a durable power of attorney. Now, you can request in the document that the person you're naming as your fiduciary, your financial decision maker, prepare a financial accounting so that you know how your finances has been handled. Another important thing to understand is how that person's authority is going to be honored when the time comes that they need to use the document. So because the document is considered effective immediately, we don't need any kind of documentation from a physician, but the financial institution, whether it's a bank or a credit union or a brokerage house, is allowed to ask your fiduciary to sign an affidavit saying that you are still alive, and the reason for that is that power of attorney ends at death. It should no longer be used. The affidavit will also say that the person who gave you the power of attorney is not involved in a guardianship proceeding in the court. And the reason that that sentence is in the affidavit is because our law says that should somebody file a guardianship for an incapacitated person, it immediately suspends the authority under the power of attorney until the judge decides whether to grant the guardianship or whether the power of attorney by itself is sufficient. So that is how the document is honored, and once it's honored, then the agent will be able to start making the financial decisions. Now, the other part to the incapacity plan addresses the medical side of our lives. And in Florida, we call this document a Designation of Healthcare Surrogate. So the surrogate is the person who stands in our shoes and makes medical decisions when something affects our ability to communicate, to reason, to make informed medical decisions. So it's important, as we talked about with some other documents, to always name alternate decision makers. There's no limit on how many surrogates you can name. You can choose to have a primary, then a secondary, or some people may choose to have two people work together simultaneously. The key is that the surrogate will have the ability to speak with the doctor, to ask for a second opinion, to make informed decisions for treatment, and if they feel that you would receive better treatment at a different hospital or facility, they can authorize transfer and discharge. Another medical advance directive that's a helpful tool is called the HIPAA authorization. HIPAA is the medical privacy law in the United States. And because of it, if we don't give permission for certain types of confidential medical information to be released, such as test results, the doctor or the hospital will not release it. So the benefit of having the HIPAA authorization is to give permission in advance to the people you name as your surrogate to have access to HIPAA information. Another helpful tool is called the living will. And the living will allows a person who has been diagnosed with a terminal illness to make decisions about end-of-life care. And some of those end-of-life decisions might involve whether a person wants to receive nutrition and hydration artificially in the event that they cannot safely chew or swallow by mouth. It might also give them the opportunity to make decisions about whether they'd like to be cared for by hospice, whether they would like to be resuscitated if the two vital functions of the body, heartbeat and breath, were to stop. And in addition to that, people can add things to a living will that reflect their own personal beliefs, whether that's based on religion or morals. For some people, they may want to create a declaration of organ donation and make decisions about whether they'd like to donate particular organs whether they want the organs used for transplantation or for medical research and study purposes. And another helpful document we call the Declaration of Funeral Designee, and this can be helpful for people that are not comfortable making their own funeral decisions. So by having this document and putting in writing what it is that they would like to be done with their physical body and who they'd like to carry out those decisions, it means that nobody is guessing when the time comes. It can also be very helpful if somebody is in a relationship or a lifestyle that perhaps is not acceptable by their family or recognizable. And so this is a way of giving permission to the person they trust to make these decisions for them. So a lot of people will ask me, when should I update my legal plan? Do I ever need to do it? And if I do, how do I know when the right time is? So I like to suggest you think about major life changes. That's a good indication of scheduling a consultation to look at what's changed and does your plan need to adapt to the changes in your life. So major changes might include a new marriage, could be a divorce, could be a new birth in the family, or somebody has passed away. If a fiduciary that you've named has passed away or is now incapacitated, you might want to reevaluate the order of the people you have designated as fiduciaries in your documents. And certainly if there's a change in financial circumstance, you win the lottery on Saturday night, that's also a great time to revisit your plan, see if perhaps there's any tax issues that might need to be addressed. So we've talked a lot about planning for ourselves as parents, and now we're going to turn to planning for our children. So when our children are under 18, we are considered by law to be natural guardians. So we can make automatically their residential decisions, decisions about school, medical consent. That happens automatically. If our child got injured, let's say, on the playground, and there was a lawsuit that's settled, we can settle the matter as long as the amount involved doesn't exceed $15,000. If it's over $15,000, then we need to do a guardianship in order to accept the settlement. But have you ever thought about what would happen if you or your spouse became incapacitated? Who would make decisions for your minor age child? So this is where the second part of legal planning comes in. And Florida has two wonderful tools to help parents plan for their children. The first tool is called a Designation of Healthcare Surrogate for a minor. Now, again, I know we have some people joining us who don't live in Florida, so it's important for you to consult with an attorney where you live to find out if your state offers something similar. So you heard me talk earlier about that we as adults can designate a surrogate in writing if we become incapacitated. We can also do that for our children. We can name a surrogate to step in on a temporary basis. If, let's say, we're traveling and our child has an accident or becomes ill, or we were to become incapacitated so we could not make medical decisions for our child. Just like when we create our own document, we want to think about naming an alternate surrogate for our minor child. The second tool to consider as part of your plan is called a Declaration of Preneed Guardian of a Minor. So it's a way of putting in writing in advance the names of the people you would like to be appointed guardian of your under age 18 children if you're incapacitated or you were to pass away suddenly. And this document creates a legal presumption that that person will be appointed by the judge as long as there is no felony in their background. So Florida has some very strict rules about who can become a guardian, and everybody is held to the same strict standard regardless of the relationship. And so if somebody has been convicted of a felony, they are not eligible to be appointed a guardian. Now you can name one person to be guardian over your child's person, meaning who they're going to live with. That person will then decide where they go to school and they will make their medical decisions. You might choose to name the same person or somebody different to be guardian over the property, over any assets that the minor child might inherit. So once the document is signed, we electronically file it with the court. And should anything ever happen to the parent, then the document will be brought to the attention of the judge and a hearing will be held to appoint the guardian. So the benefit of having these documents are mostly that you get to make the decision. You choose who's going to be surrogate and who's going to be the guardian. So you heard me say earlier that as soon as our children become 18, they become legal adults. We may think that they're not mature enough yet to make certain decisions or make good choices, but legally, the choice is all theirs. They make their own medical decisions and they get to make their own financial decisions. So believe it or not, young adults are just like us. They also need a legal plan. There can be unanticipated events that occur that can change life in a moment. We see that with car accidents. We see that with kids not being able to manage their alcohol intake and being swayed or persuaded when they're attending a party at college and then they drink too much alcohol. So it's just as important for our 18-year-olds, our young adults, to have a designation of healthcare surrogate as it is for us. It's going to give you the ability to make those decisions should anything happen and they're temporarily incapacitated. It'll also mean that you've successfully avoided having to do a guardianship in the court system. And that saves you privacy as well as the cost of a guardianship. As I mentioned earlier, I do recommend at some point, might not be between 18 and 22, you might want to wait until they start to work and they start to accumulate assets, but it is a good decision for our young adults to also have a durable power of attorney just like us. And then there are all those medical advance directives we talked about that are available to them too. So when you're thinking about picking out the college, planning the graduation party, planning the last family vacation, do make it a point on your priority list to talk to your children before they leave home, whether it's for college or enrolling in the military. That's really the ideal time to get the documents in place. If for any reason that didn't happen, then I do encourage you to still talk with your children and then plan a time for them to meet with the attorney when they come home for Thanksgiving break or perhaps winter break. So I'd like to share with you some tips to help you start to get organized and motivate you to take the next step after tonight's webinar. So start by talking with family and friends that you might select to be your medical and financial decision makers. Have the open dialogue. Then, after you have the dialogue, start to select your beneficiaries. Know as much as you can about your beneficiary so we can help you determine whether that person should receive their inheritance directly or whether it should be in a trust of some type. You want to choose trusted people to be the trustee, or if it's a larger sum of money you're going to leave, you might want to consider an independent trustee, such as a trust company. You want to think about selecting a surrogate as well as a guardian for children that are under age 18. And you want to talk with your children probably between their 17th and 18th birthday about the plan you created for yourself and why it's important that they also have a plan once they become an adult. And then the next step is to select and meet with an experienced, qualified elder law attorney to help guide you through the process to creating the right plan for you. So here are some tips to help you choose an elder law attorney wherever you live. First tip is ask the attorney about their practice areas. How often do they handle elder law issues? What percentage of their practice is spent helping clients on elder law issues? You can ask, you can even go to the state bar site to find out, is the attorney board certified in a specialty? So just like if we were having a heart issue, we would seek out the guidance of a cardiologist. Medicine has specialties, and so does law. You want to ask the attorney's office if there's a charge for the consultation, and will the attorney provide you with a written proposal for services after the consult. You can also ask the attorney's office for a client reference that you can speak with. And as I mentioned, the Florida Bar website has a lot of information about attorneys. And you can also, if you're in a different state, go to the NALA.org website and help find an attorney that focuses on the elder law area in the state where you live. I do suggest you look to see if the attorney has a website. Hopefully there'll be client reviews that you can read and get some idea of what kind of experience you would expect when meeting with the attorney. And that's probably the most important thing, is your customer service experience. Are you comfortable? Are you able to talk openly and feel that you're getting the guidance you need and that the information you're sharing is being kept confidential? So at this time, I'd like to take any questions that you might have. You're welcome to unmute your microphone, or you're welcome to write in the chat box.
So, Stephanie, a quick question about ABLE accounts. We've set up an ABLE account for our, sorry, I think I'm feeding back there, for our disabled son. I don't recall any place where it was made easy to put that into a trust. So we did not set that up in a trust. Is that something that should be put into the special needs trust for him?
Well, an ABLE account is different than a special needs trust. It's another option. And an ABLE account allows people, such as the person with the disability, to put their own funds into it. So if somebody's working, they might choose to contribute their employment wages to the ABLE account. One of the nice things about the ABLE account, and this is similar to the special needs trust, is that the assets in the ABLE account don't count. under the Medicaid or the SSI rules.
Right.
So in case somebody might not spend the money fast enough and it's going to accumulate, it can accumulate safely in the ABLE account. Also, family members can contribute. There are limits as to the total contribution from all people during a
Per year.
calendar year. So you want to be mindful of that. And one of the nice things here in Florida is we did change the law recently. And so there is no Medicaid lien against an ABLE account.
Right. So, but I guess the question is really about the naming. So it is kind of like a standalone special needs trust, is it not? It can be in that person's name and be either myself or my wife as the trustee.
Well, not exactly, because an ABLE account is administered by a specific group. So you are technically not administering it. In Florida, we use the same company that administers our Florida prepaid college plan program.
Mhm.
So
But
that's
I guess in the accounting, when somebody dies, it's really kind of side of your estate planning, right? Because we set it up separately.
correct, it is.
Okay, all right.
Mhm. Thank you, Robin. Good question.
Okay, thank you.
Does anybody else have a question they'd like to ask?
Okay. Did I just turn it off?
No, you turned it on, Rosa.
Oh, okay. So, our needs are really for our grandchild, who is now 3 years old, but does have sensory issues, along with some medical issues. And so we have 3 children, 3 grandchildren, for whom 2 of them we have the 529s, etc. We don't know what to do with this one who lives in Chicago. So I thought that we would actually be going through options for a minor.
Well, one of the options, and you may need to talk to the parents to get an understanding of what the pediatrician is observing, when the child goes in for their checkups. You might then want to consider putting the inheritance for this grandchild into a special needs trust.
So how would that special needs trust differ from what we just went through?
What do you mean what we just went through?
In other words, this procedure, it's actually can be setting up a trust for almost anybody. But for a minor with special needs, how would that differ?
It wouldn't. We would still be looking at a special needs trust.
Okay.
The special needs trust can be used for a person of any age.
Okay.
Thank you, Rosa.
Thank
Does anybody else have any questions?
Well, I'll ask one if I'm not hearing anybody else ask a question concerning traditional IRAs. Those, how do you set beneficiaries on? I was told not to put those into to put them into the trust, the revocable trust. So at
that,
this point, I've set them up, basically it would be, if I were to pass 100% to Deb, and then if he passes, then it would be divided 50-50 between the able-bodied children and not going into the trust for our special needs trust. But with the verbal commitment from the two children that's what they would be using those funds for, coming out of the traditional IRA, which has all kinds of conditions because you have to pay taxes on it, et cetera. But
well, everybody has to make the decision that's right for them. If you don't designate the special needs trust as a beneficiary of an IRA, there's no guarantee that the monies will end up being used for that beneficiary. And again, that's not saying that the other beneficiaries wouldn't share it. But again, there are tax issues involved, number one. And number two, there's no legally enforceable requirement.
right.
So, it can be done, and it just has to be done correctly to designate the special needs trust.
Okay. But you wouldn't put it into a revocable trust and then have it be divided there and then go to a special needs trust.
Well, again, everybody's situation is different. And if you designate a trust as a beneficiary of an IRA, there are additional IRS requirements to do so. So it's not
Okay.
always worthwhile doing that. It depends on the value of the IRA.
Okay. Thank you.
You're welcome. Well, I'd like to thank everybody for joining me this evening. And I just want to remind you that throughout the month, we hold a webinar series. You can go to the calendar of events to register. And if you missed a webinar, but you had planned on attending it, we do post the recordings about a day afterward, and you can find them both on the website or the YouTube channel. And if you go to the Contact Us page on the website, you'll get a document checklist to get you started organizing and thinking about what you need, as well as a gift certificate to use on your initial consultation. So I want to thank everybody for starting my week by joining me. Stay safe, stay healthy, and have a great week.
Thank you. Good to see you.